Hey mates across the pond. Yeah, speaking to you, Brian and Mark and anyone else who's listening. And your followers, of course. I get it. We're at that stage now, is put up or shut up. And that's actually going to be the title of my video. So you're asking me to throw it all out there. You're not going to at all investigate anything I said. You just want to see how it all works so you can identify how you became obligated through being a tenant. So where did I or you become a tenant? So I accept, you know, it really is pushing me past my general laziness, whereby, I'm not receiving any money, or do I, sell any wares according to what I offer to the public. And so I generally just speak to the issue, provide the links, and then for people to obviously look to those links and see whether or not I am on the ball or I'm on the bus, as the old saying goes. So for you guys, and I get it, you like to show, pinpoint exactly how the progression works, and I am going to take you up on the challenge. So this is going to be the video on put up or shut up on either side, and hopefully we can now move from this point on to where we are proving the obligation and where we settle the matter. So let's begin, shall we, on our little journey into how it is that I or you are construed to be a tenant based on exactly what you have said.
Right? When did you, me, or anybody else agree to be a tenant?
Brian, I get it. It's a difficult subject to get our heads around about what is law and equity. But we can agree that they are two different subjects nonetheless, and being that they are, should we not first both comprehend what law is? I'll just stop here. Everyone listening to this now, ask yourself who's responsible for learning what law is, whereby I am 100% responsible. And so when I mention William Blackstone, who is obviously a greater learned man than I will ever be in these subjects, then that's where I begin from. So with this as an introduction, let's talk some verifiable facts into which you guys are both seeking. It appears we are at an impasse. My suggestion is we are both claiming we want to arrive at the truth, so as to stop this incoming tsunami of technocratic slavery for us and our lineage. And so my suggestion is this. You put out a challenge to prove the obligation. I said the obligation essentially exists in the very fact through the notice of your very own actions as a tenant for life within English law, whereby you have never made your intent known at age 21 to vest the legal estate held exclusively in the common law. So simply, it is from a lack of your own inaction and mine, or anyone else's, that the law, out of necessity, governs over your current rights via your notice volunteered and verifiable actions in society. This is my basic claim that I must prove to the both of you. So it is now as far as I'm concerned, and I expect others, for me or you and Mark to put up or shut up. So it is up to me to meet this challenge, to answer your recent question, essentially show me where I've agreed to be a tenant. So once this is proven, would then mean you have an obligation to act according to the level of tenancy you have chosen to use. Correct? So, as men to be of honor and conscience, I propose to bring this video, compared to your own study, to a learned judge, law professor, the ends of the court, so as to receive a third opinion on who is right. All right, mates? You put on the challenge, so let's stand upon your own words. I will prove your tenant query, as I agree, it's a good question, and so a good origin to get our heads around. on how we create an obligation in municipal laws that compels us to perform subject to our own current held interest in equity. And sunshine, because I see that you like to use that name, I have no idea how you even arrived at willingly being a public figure. Next, stating you want people to prove you are right or wrong, state you are speaking the truth, and then become a victim to people actually taking you up on your offer. It is nothing personal. I have done other videos of your same type. You're not a victim when it is you who is searching for the truth. So, first of all, let's begin. What is English law? For greater certainty, the English law, the history of the law comes from conquering of lands, not people. In comparison, the Jews perfected banking because they did not conquer land. They conquered people through the slave trade, and now today through the banking scheme. English law is a hierarchical system of landholding. All land interests must never be held in abeyance. Never. It means all land interests must be held in some title until it remains in esse. And if we go in through here to abeyance, I've highlighted, the law requires, however, that the freehold should never, if possible, be in abeyance. Where there is a tenant of the freehold, the remainder or reversion in fee may exist for a time without a particular owner, in which case it is said to be in abeyance. As for the word esse, essentially it is just in being, okay? We are just in being, a thing in existence. And so that is generally what esse means. Let me continue. This is a must. There's no exceptions while using the English law system. Evidence is simply what law is, period. So, to which equity is not English common law, but a right of beneficial use to the land through a completely different set of rules over a right to land within English law. Roman Church, the Jews, government, corporations, as an example, are all creatures of equity. Nowhere in the English common law has ever any perpetuity institution has ever or will ever hold a right in the common law, as it needs first to be a tenant for life. This is fact. So every book that speaks to the history of law and equity, every case recorded beginning in the 12th century until now, emphatically states what I before said. Fundamentally and simply, in the same manner, if you were born with a penis, means you are identified as a male, which makes there is no argument, well, based on the old criteria anyway. Pick up a law book. I directed you guys to William Blackstone, so to do some basic research. And so now arrives us in the fact that the main question is to prove I am acting as a tenant. Where is the proof? Fundamentally, no man or woman can have any rights in English law unless they have first a capacity of a tenant in order to effect any right in land. It is impossible otherwise, unless you are a monarchy. Again, research what is English law. Do not take my word. As a note, I will add, the law does not need evidence. It is black and white. It is what it is and cannot be anything else. It is the strict settlement of land rights. Equity is different. Its laws are based on conscience. It looks to the spirit of the agreement and why it is arbitrary and so relies on evidence. This is basic law and equity 101. And so why without basics one will never begin to comprehend their own actions within a society of men and their obligations within any society. So are we good so far? Back to tenancy. Listen to the words again. English law after the 12th century and so arriving today came from what 100% verifiable system of law? The answer is the feudal land tenure system. Tenure means what? And let me click on that so we have something to refer to. It's the right term or mode of holding or occupying something of value for a period of time. In feudal law, the principal mode of system by which a person held land from a superior in exchange for the rendition of service and loyalty of the grantor. But like this one, according to English law, all lands are held immediately from the king as Lord Paramount and supreme proprietor of all lands in the kingdom. The idea of tenure pervades to all considerable degree the law of real property in several states. The title to land is essentially allodial, and every tenant in fee simple has an absolute and perfect title. Okay? But in medieval England, tenure referred to the prevailing system of land ownership and land possession. Under the tenure system, a landholder, called a tenant, held land at the will of the lord, who gave the tenant possession of the land in exchange for good or service provided by the tenant. The various types of arrangement between the tenant and the lord were called tenures. The most common tenures provided for military service, agricultural work, economic tribute, or religious duties in exchange for funds. The king was the supreme owner of all tenures. All tenures escheated back to the king, as they were all filtered through the king, who could never be made a tenant. The king was the only legal personage that was not a tenant. For the logical fact, he held all land rights. Thereby, every other person who had a right to land held a tenure according to his own status. Women and children could not hold a tenure. The Roman Church and Jews could not hold a tenure of this sort. It was a personal agreement between the subject and the king to use the land according to the status of the individual, which begins the foundation of English common law and the concept of jurisdiction. Tenure and status were next regulated through the laws of inheritance. Now read the Magna Carta for the first time with new eyes. What are they discussing? Individual rights of men, women, and church, or rights to land? Equity is not the common law. It is the second level of use to land, which means you do not hold the common law title. Equity is the beneficial of the land through the possession, but season remain in the common law as a separate legal estate. Season, the possession of an estate of freehold. Season was used in contradistinction to the precarious kind of possession by which tenants in villanage held their lands, which was considered to be possession of the lords in whom the freehold continued. And you can pause this and look at the rest of this at your own leisure. It is a second level of use to land, which meant you do not hold a common law. Are you both prostrating under the right to equity now, willingly? And then if you think equity overreaches common law legal estate, you obviously do not understand what is held in common law and what is held in equity, as they are 100% two different subject matters, so of complete different jurisdictions, period. Like the Lord's temple hold a different interest as a tenant to land than those of commons. One is responsible for the common law originating legal estates, and the other, the commons, are responsible for the equitable interest titles. Again, basic 101 law and equity. Now I hope I got this in the right order. Let's see, what do we got here? I believe it's Act of Settlements. And you brought this to our attention as well. And whereas the laws of England are the birthright of the people. It's okay to say the birthright of the people is the English law, but it is not okay to next be without the knowledge of what English law is, to next even comprehend what that birthright means. It must come logically from the ability to formally be conclusively explained through what is law. So it is impossible to first hold a right in English law or equity unless you use the capacity of a tenant. It is impossible. What we have here is the Settled Estates Act. Why am I bringing that up? Oh, that's a nice little unicorn there, isn't there? Because it's an act to facilitate leases and sales of settled estates. The Magna Carta, Statute de Donis, 1285, Clea Emptoris, 1290, Law of Mortmain of the same year, Statute of Uses, 1535, the Cestui Vi Acts of 1540, 1666, 1707, Abolition of Tenures Act, 1660, Bill of Rights, 1688, Act of Settlement, 1700 and 1701, Settled Estates Act, what we're looking at right now, 1856, are all proof of tenancy and tenure. Every single one of them. Now, Settled Land Acts, all culminating into the Settled Land Act 1925, to which this act speaks to the strict settlement of land, not estates. Because as we read right here, an act facilitating sales, leases, and other dispositions of settled land. We are obviously talking about a different subject matter, which verifies the duty and power of a tenant for life in the 1925 Act. The Law of Property Act 1925, which states it's an act to facilitate the use of land in equity. So it's a separate subject matter from the Settled Land Act of the same year, to which the only interest, one, as a tenant can hold in land, is a fee simple absolute or leasehold. Period. We go right here, legal estates and equitable interest, the only estates and land which are capable of subsisting or have been conveyed or created at law are an estate in fee simple absolute in possession, doesn't say season, a term of absolute years. Now if I just return to the, let's get back to the table of contents. What is this act speaking from under? Is it trust for land? Or are we speaking, now where is that? Am I looking at the Law of Property Act here? I believe I am. I'm looking for trust of sale. And somehow I passed it. Trust of land. Dispositions on trust for sale. Okay, so that is in order of how things are set up to read the law, to which it comes to trust of lands and discusses underneath it, the trust of sale, and it understands or comes underneath it trust of land, to which the trust for sale, if you're speaking the Settled Land Act, to those settlements of land, strict settlement, they are not speaking to the trust for sale. Okay, so to which the only two interests, one, as the tenant can hold in land, is a fee simple absolute or leasehold, as I've already discussed. And now we'll go down And we're going to capture, I'll put this in the background. So then read the three different type of interest in common law, which I have just put up here. And let's begin with how it starts here. With the passage of the Tenures of Abolition Act in 1666, although land was still technically owned by the Crown, peasants could buy and sell their rights to land they were living on, as well as pass it on by will or by gift. This type of property right became known as an estate in free and common socage, or free estate. This is why property rights over land are known as real estate. An estate, in English medieval legal parlance, was the amount of time over which one held property rights. There are three different types of estate: fee simple, life estate, and fee tail. And if you remember, we went to the law of property. What were there? Only those two estates. They were the fee simple absolute or leasehold. As you see, the common law interest is a completely different matter as it pertains to one single individual who holds this type of tenure versus those of perpetuity instruments who hold under equity and the laws of property. Now, do you or Mark hold, rent, mortgage, been willed, gifted, granted, lease, control, or otherwise a property under government? Do you live in a house, a shack, an apartment, a condo, a quonset, a shed, a mansion, a castle? Means you have a fee simple absolute. Thereby means unequivocally you have to be a tenant first. Where is my obligation, you are asking? Where is it? And prove it. As they speak from their homes in the capacity of a tenant. Why not ask what are the obligations of a tenant while you're using the status of citizen? Well, just like what we just read of the peasant. Let me continue. William Blackstone, you know the books which proves all of this, is the entire interpretation of law and equity as a tenant until now. Is the principal book used by all courts of common law and equity, and because either of you refuse to pick it up and read it, somehow proves your opinions are right. Blackstone's commentaries on the laws of England, and I've got the wrong one there. That's the one I want. The rights of things, and we'll look at the very first sentence. We come now to treat of the estate with respect to the number of connections of their owners, the tenants who occupy and hold them. The tenants. Now, let me just pause this for a minute. I'm going to get my case law book, and then we're going to look to words with our certain sentences within that case law book to help bring this home that we are all acting as tenants. To include this is going to be a little bit more difficult because it actually is a physical book. And there we go. Case law and notes on land law, Bor-Alaskan. Okay, and this is the type of material that I read from in order to come to understand what is law. Bor-Alaskan, by the way, we'll read the Honorable Bor-Alaskan. He's a Justice of Appeal in the Supreme Court of Ontario, formerly Professor of Law in the Faculty of Law, University of Toronto. And let me go into the published date, into the published page, so we have that as well. Okay, we're going into 1958 and reprinted in the USA in 1966. Apparently, the USA also has interest in learning the law. So if I go to, and I'm going to bring it, chapter 2, it's called, it's the Doctrine of the States. And I'm not going to read a lot here. I'm just going to, first of all, I'm going to show it. So if you guys can, pause it and read it for yourself. Let me see what I got here. Sorry, guys. I'm trying to hold this thing straight, and I'm bent it way over here, and everything's backwards, as you know. Anyway, okay, so here we are. So I'm going to read. It says the tenurial features of the feudal system emphasize that a person holds land but does not own it. True. After Clea and Taurus, the holding would come more and more to be only of the crown, but the concept has remained to this day. That's pretty much exactly what I want to extract from that. We're going to go to chapter 3, estates and fee simple, and I'm only going to read the first line and the last line of that first paragraph. Oh. Because you guys I get it. You like to see the proof. All right. Says the largest or highest of the freehold estates is the fee simple. The holder of an estate in fee simple absolute is, to all intents and purposes, an absolute owner, although technically he is a mere tenant of the crown. Now, unless you want me to bring in every single law book on how the English law system works, your birthright, and so create content I have already created through all my videos, debate me on this, that you are both acting to the capacity of tenant right now by the very fact you are holding an interest under government in fee simple absolute. There is no exceptions. Now let's put some icing. Actually, you know what? I'm not going to go there right now. And as such, that you are a tenant creates an obligation subject to the right that you have currently voluntarily held to an interest in land made evidenced by your very own actions. So you are agreeing to hold property right this very second, and then wanting proof of your obligation that allows you both to be treated the same as everyone else who holds the same type of interest under commons under the government elected. Now, let's put some icing on the pound cake that you are now both enjoying. I hope you are anyway. Concerning what it says right on your very own title deed. Pull it out if you got it, that'd be great. Representing who the owner is, subject to the birth certificate that is owned by the government. And does it not also say tenant? But if it doesn't say that, if it's not recorded, if it doesn't say that right on your title deed, as it does here in the province that I am in right now, I would get on your blowhorns or write your land titles registration office and simply ask them, as owner of this property, the holder of this title deed, if you are not first to be construed to be a tenant. Just ask them. In fact, do not rely on those who wrote about the law, any law professor who read Blackstone. Don't rely on any law university, the Inns of the Court, the High Court and Common Law, the High Court of Chancery, or what I say. Use your very own title. You both are evidently holding right now, and then say after learning who you're screwed to be agreeing to hold property as, so to act in the capacity of tenant, then ask, where's my obligation to perform the duty as a tenant? In similarity, it can be compared to filing a court action against your landlord and next trying to argue where's my obligation to pay them rent. You are holding possession right now. You want the right to enforce your title rights without the responsibility to be held to this obligation. Somehow you have arrived at this point, and your team and followers, that you do not want any agency who holds a superior title the right to enforce an obligation upon you while you hold the very obligation that gives them this right. I thought you and Mark, the peacekeepers, peacekeepers platform, namely, all use equity. And now you're not even coming in with clean hands. Here are some of the maxims, as you saw in the background, you're agreeing to. You are both going to love the last one, which I will highlight. And there it is. Equity imputes an intent to fulfill an obligation. Here's from my local land title act. I mean, look to your own. It'll be similar. And I extracted section 23, effects on indefeasible titles. Those are being fee simple. And looking at the criteria in which then establishes the parameters of what would be an indefeasible title and fee simple. Okay? The existing or subsisting conditions, provisios, restrictions, exceptions, and reservations, including royalties, contained in the original grant. Doesn't Parliament and government get a grant, or contained in any other grant or disposition from the Crown? Okay, but I want to get to these last points, namely H and I. The right of a person to show that all or portion of the land is, by wrong description of boundaries of parcels, improperly included in the title. The right, sorry, I didn't want to do H, but yeah, you got it anyway. The right, so you right now, because you're holding the title, you're asking for these rights, and now looking for an obligation to perform under when somebody's asking you to do the same. The right of person deprived of land to show fraud, including forgery, is which the registered owner has participated in any degree. But I love this one. A restrictive condition, right of reverter. Reverter, possibility of a contingent future interest in real property that a grantor of a determinable fee possesses after he or she has conveyed properly. So the possibility of reverter arises when the grantor of real property has conveyed land subject to the possibility that the state will return to her or to her heirs if a certain specified limitation occurs. Now this is not reversion, to which you also have a right as always as a tenant for life, because you look at the Settled Land Act, it's going to explain that all to you if you understand what reversion is. But the point is, I have shown you where the strict settlement is and where the law of property is and what land interest that you're holding. To which then obviously forms an obligation because of the very fact that you're holding that interest in right of those who hold the higher estate interest, which is the strict settlement, the Settled Land Act, which is a completely different right as a tenant for life to land than those of estates or those of property. So, you both began the public challenge. You guys did. And so it appears because of your own lack of knowledge and the true answer does not fit within your own criteria of what you think law is, you will never honor the challenge based on the criteria you set. I mean, you guys said it's impossible to meet ever, which I've been saying, ever to meet your criteria because it doesn't even exist in the first place in order to be met. Essentially, we want proof of the obligation, while us obviously voluntarily to act as a tenant in law and equity. So take what I've said, even what BBBB said, BBBB, yes, our black belt barrister, to a law professor or a learned judge and put down what I said, proving the obligation by your very own actions, with your course or explanation as serving as the comparison that you now offer the public. So as to make good on your challenge you have willingly made out in the public and to which I responded. And this across the water idea, you stay on your side of the pond and I on the other. We are talking about English common law. We're not speaking to individual territorial rights held under a trust for sale. And with that, sure, if with lack of holding a mic right now that I can drop, the only issue that you guys are ever going to have with everything that you're going to do is your inability to understand the capacity that you have to be holding in order to affect any rights in English common law or in equity. Thank you guys for listening. God, peace be with you. I think this is my longest video. Pretty close anyway, it might be. So thank you for the challenge and, pushing me past my own, let's just call it laziness for lack of a better word.